First matter to come before the court this morning is Microdynamics Group Inc. versus Equity Trust. Both parties will have 15 minutes in which to argue your case. If you're the opponent, you can retain up to 5 minutes for rebuttal. If you want to retain any of that time, let me know. And keeping track of the clock and keep you apprised of the passage of time. We are being visually and audibly recorded and posted online, so try to remain behind that podium as much as possible. We have read your brief and are ready to proceed when you are.
Thank you, Your Honors. Good morning. My name is Kathleen Honor from Stark & Knoll, and I represent the appellant Microdynamics in this matter. I'd like to reserve 3 minutes for rebuttal at the end of the argument. Microdynamics is here to ask this court to use its de novo review to overturn the trial court's decision granting Equity Trust motion for summary judgment and to send it back to the trial court with an instruction to actually grant Microdynamics motion for summary judgment. There are 2 main reasons why the trial court's decision should be overturned. First, the trial court's decision violated Rule 56. The trial court improperly evaluated witnesses' credibility based upon deposition testimony, and then the trial court took those credibility decisions to failed to construe evidence in a light most favorable to Microdynamics. The second reason why the trial court's decision should be overturned is because Equity's entire defense, the defense that it set forth in its motion for summary judgment, was based entirely upon a unilateral mistake or fraudulent inducement, but the trial court ignored necessary case law that required Equity to bear the risk of any alleged misunderstanding. So going back to how the trial court violated Rule 56. The trial court took testimony out of context while ignoring other on-point testimony and evidence. The fundamental fact here is that there was a valid contract between Microdynamics and Equity Trust to complete projects that were set forth in 2 different RFPs, requests for proposals, one for batch printing and a second for ad hoc letters or one-off letters. I'm here to tell you that Microdynamics was able to perform all of the tasks that were set forth in both of these RFPs. These RFPs became the source of months of negotiations, discussions, and demonstrations between the parties that ultimately led to a contract between those 2 parties. Microdynamics should have been permitted to perform this work, but after the contract, for the very first time, Equity suddenly drastically changed the scope of that project and then breached the contract. The trial court said that there was a dearth of evidence that Equity Trust, made any changes to the scope of the project, but that's simply not true. This court could take a look at Exhibit K to Equity Trust's motion for summary judgment. That is Microdynamics' response to the ad hoc RFP. In that RFP, it lists forth about 30 or so tasks that Equity Trust wanted Microdynamics to be able to perform. Microdynamics is able to perform every single one of them, and it attached about 50 pages of literature explaining how it planned on performing those tasks. It detailed the solution that it planned on setting forth. If the court compares that Exhibit K to Exhibit T, also attached to Equity Trust motion for summary judgment, that shows Equity Trust post-contract requirements. This was a document that was sent out after the contract was signed, and it suddenly set forth brand new requirements that were never included or contemplated in the RFPs, that were never discussed as the parties were demonstrating and discussing the contract that ultimately came into place. These requirements asked for drastic changes where instead of just being able to print a one-off letter, they wanted to be able to know which Equity Trust employee was making changes. They wanted instantaneous changes to be made. They wanted to be able to track which printer at Equity Trust these documents are coming from. None of these issues were presented in the original RFP.
And so did the original RFP contemplate a software system that would have been necessary for these ad hoc letters?
No, Your Honor. It focused mainly upon templates that were used more rare. It wasn't a batch printing, something that goes out monthly. It would be something that was used more infrequently, but they were template-based. Now, the RFP did request the ability to make changes, and Microdynamics was fully capable of making those changes. And if you look at the attachments to the Microdynamics response to that RFP, it actually says changes take about, I don't remember if it was an hour or a day, but it contemplated that changes could be made, but it wasn't instantaneous. And if the court looks at page 10 of my brief, there's testimony from Vita Horsfield. She is an Equity Trust employee, and she actually went through some of the ad hoc RFP with the post-contract requirements and admitted they weren't in there. So if these requirements were suddenly set forth after the contract, it was not what Microdynamics bid upon, it was not what Microdynamics demonstrated and discussed, how was Microdynamics supposed to know about it? So Microdynamics did what it was entitled to do under the contract. They sent an email saying, hey, give us some time. We want to try to figure out how we can make this work, but we need some time. It may have an extra cost. Now the trial court placed a lot of emphasis on this email. It's the email from Microdynamics employee Jeremy Youngren. But Mr. Youngren did not breach the contract. He never said we're not doing it. He said give us some time. Paragraph 1 of the contract, which is attached as Exhibit A to the complaint, actually says that if something new comes about during the terms of the contract, 1, Microdynamics doesn't have to do it, but 2, if Microdynamics does endeavor to make these changes or do things in a certain way, there may be an additional cost. So that was contemplated by the contract. The trial court did focus on some other testimony and other evidence that came forth and tried to say that Microdynamics lied the entire time and was never able to perform any of the tasks under the RFP. In addition to Mr. Youngren's email, which we just discussed, the trial court focused heavily on Microdynamics employee Adam Strack. And he used his testimony to say, Microdynamics admits it right here, they can't do it. But when Mr. Strack is testifying, he's actually testifying to those requirements that were sent after the contract was signed. What Mr. Strack actually testified to when he was talking about the RFP is, what I wish Equity had asked for is what's in this RFP. We can do every single one of these things. Instead of looking at the testimony as it was in context, the trial court just took something, pretended that he was, or misunderstood that Mr. Strack was testifying about the RFP when he was not, and said Microdynamics was never able to do this. The trial court also put great emphasis on some internal emails that took place at Microdynamics. But the timing is important for these emails. The first batch of emails between Microdynamics employees took place in March of 2014. These were before Microdynamics responded to the RFP. In those emails, Mr. Strack and Mr. Laube, among a few other Microdynamics employees, expressed some sort of concern about what this RFP was looking to do. But when you look at testimony, which the trial court opted to disregard, Mr. Laube admitted that there was a meeting that came forth. The Microdynamics team, both the sales and the technology side, got together, discussed the contents of the RFP, and they devised a solution together. After that meeting, Mr. Laube said that he was comfortable moving forward. They put together their response to the RFP. As I mentioned, it included about 50 pages of extra literature explaining how they were going to do the RFP. And from that moment on, there was silence at Microdynamics. There's no discernment, there's no contemplation about why are we doing this, why are we spending the time, we aren't going to be able to perform. The next batch of emails that come up are not until September or August. It's after the contract was signed. At that point, that's when Equity started unrolling these post-contract requirements for the very first time that were not contemplated ahead of time. That's when Microdynamics again starts saying, whoa, we need to figure out how to do this. But again, that was after the contract. Everybody at Microdynamics was comfortable with the contract moving forward when they responded to the RFP back in March. Now, as I mentioned, Equity's entire defense for its breach was based upon unilateral mistake and fraudulent inducement. Equity is going to try to say that we don't even need to get to this point because the trial court said that Microdynamics breached. But the trial court actually granted Equity's motion for summary judgment, which relied upon these two theories. The contract and the underlying project was entirely Equity's idea. They were doing a big software overhaul. They set out these RFPs. They knew what they needed to do to perform. They know their business best. Equity admitted that it solicited responses from multiple vendors, multiple companies. They met with people. They flew Microdynamics out. They had in-person demonstrations, they had virtual demonstrations, they had conversations over the phone. They were vetting out this project. So if there was any unilateral mistake or any fraudulent inducement, Equity needs to bear the risk for that, and that's what the case law says. Equity knows this project best, and it is absolutely undisputed that Equity prepared the RFPs. Equity had access to more than 50 pages of literature about Microdynamics' proposed solution before the contract was entered into. Equity requested, and Microdynamics performed several live demonstrations, again, before the contract was entered into. And Equity Equity admitted that it felt very comfortable with Microdynamics when it entered into that contract. So if Equity wanted more than what was being demonstrated or more than what was being discussed, why did it enter into that contract? Equity is the one that bears that risk. Microdynamics had no indication, no hints, nothing from Equity as it was entering into that contract that there was something that they were not going to be able to do. Microdynamics wouldn't have entered into the contract if it wasn't able to perform. So for these reasons, Microdynamics states that the trial court failed to apply necessary law and also failed to apply the appropriate standard from Rule 56 by making witness credibility decisions and failing to construe evidence in its favor. And Microdynamics requests that the court overturn the trial court's decision and use an instruction to grant judgment in Microdynamics' favor. And I will reserve the rest of my time.
So one quick question. Your position is when Microdynamics rated itself as a 4, able to do all the functions that Equity Trust inquired about, that was prior to what you assert is a change in the terms of the contract?
Correct, Your Honor.
In other
Yes.
words, at the time they could fulfill all of those?
The RFP, Microdynamics undeniably is able to perform all of the tasks that were set forth at a 4 in that RFP. It was the terms that came about after the contract.
And I suppose the other side is arguing that you wanted the business because the bulk of it was the printing aspect of it, and misrepresented, figuring you could figure it out later on.
That is exactly what the other side is saying, and to that we say no. We said that we were able to do it, we demonstrated our proposed solution, and we gave them documents showing how we were planning on doing
The RFP as
the
it was
RFP
stated.
as it was stated.
All right,
Exactly.
thank
Thank you.
Good morning, Your Honors. May it please the court. My name is John Alton. I'm counsel for Equity Trust Company. The trial court correctly decided the issue on Rule 56 before. It is clear that Microdynamics either breached or anticipatorily breached the contract between the parties, and that Equity Trust was privileged to walk away from the contract. If you look at the timeline that's laid out in our briefs, in the words of Microdynamics' own employees contemporaneously in their emails, which are the best evidence of what was actually going on, the picture becomes clear. And that picture is that Microdynamics never had and never could provide that letter management software solution that was requested in the RFP, that was part of the contract, and that was expected by both parties. And again, in our brief we discuss some of the inferences that you can make concerning why that happened, but the why isn't mission critical to the determination here. The why adds flavor for the what, and the what is that from day one, through their own attempt to squeeze more money out of Equity Trust, they knew that they couldn't provide what Equity Trust needed. And I'd like to point to 3 emails in particular, and this responds in part to the reply brief filed by Microdynamics here, which suggests that the problems were internally discussed at Microdynamics just at the beginning and at the end. And that would be enough, but there's also a problem in the middle. So let me just be clear. In March, the parties are talking about this transaction. Equity Trust makes it clear that we're looking for something that's not just bulk mail and printing. Bulk mail and printing is easy. That's what Microdynamics does. Dale Hartman, our representative, asks Microdynamics, hey, can you guys give us a letter management solution? And the terms of that RFP, it's a 10 or 12 page RFP, list what we need. It's talking about a separate software solution. Not a function, not something that's cobbled together, but a solution. Microdynamics responds just a couple of days later saying, yeah, we can do every single one, 4s across the board. Frankly, they're the only bidder that we had that had 4s across the board. During that time period, they're having this internal discussion. Our RFP comes into Microdynamics, I think it was on a Friday. It comes in late in the afternoon. It gets circulated among the executive team of Microdynamics. And Dan Lowby, one of their executives, says, kind of telling everyone to pump the brakes a little bit on this project, I believe we usually only receive the output files from such client-owned or third-party systems. Unless we are willing to design and engineer or acquire a client-specific solution, I'm not sure we can provide a meaningful response. That's clear, that's contemporaneous evidence of what at least one Microdynamics executive was thinking. And it's not hard to imagine, right? The salespeople go out there trying to get the sale. They come back and need to talk to the technical people about, hey, can we actually deliver? And they raise this concern.
This was either in March or September, which packet of email?
I'm sorry, this is in March. So this is, we get the email, we get the RFP. They're talking about it at the beginning. Lobby says, hey guys, what they're asking for is pretty far afield from print and mail. They're asking for a separate software solution. Unless we design and engineer or acquire a client-specific solution, I don't think we can respond. This is consistent with Mr. Strack's deposition testimony where he talks about Microdynamics isn't a software shop. They're a printing company, print and mail, both print and mail. They do val packs, they do bills for Blue Cross Blue Shield, things like that. Nonetheless, they want that work. They say across the board, we can do this.
Well, was that part of the discussion where one person raised the issue and the rest of the parties to that meeting disagreed with him?
Well, it's
Said,
interesting.
yes, we could do this?
Your Honor, it's interesting. Presumably, yes. There isn't much follow-up in terms of emails to that. Now, 3 days later or 2 days later, they respond with 4s across the board. And at deposition, they talked about how they mulled it through internally. But there really isn't anything that's objective that addresses that issue.
Might that be an issue of fact?
No, Your Honor, and I don't. And I think Ms. Honor casts this dispute as one of credibility, as though it's a he said or she said. And here, the trial court wasn't judging credibility of one witness versus another. It was looking at a whole raft of evidence that suggested that no reasonable fact finder could find that Equity Trust wasn't privileged to walk away from the contract. That's not judging credibility of a witness, it's looking at the totality of the evidence. Now, if I can get back to my 3 emails. So we've got March at the beginning. I don't think we can do this. They talk. They're negotiating back and forth. It's undisputed that there were discussions concerning the demonstrations of what we can do. The Equity Trust witnesses, Vito Horsfield and Dale Hartman, testified that, we explained what we needed. Equity Trust needs to be able to print out specific documents related to a particular investment that it's handling for one of its IRA customers. That it can put in a physical package in Ohio, in its offices, along with a deed of trust that needs to get signed. Or if someone's buying gold, a custodian slip or something. We need a letter management solution that will allow us to deal with actual letters, not just templates. We're not just spitting out data files to Illinois to be dropped into form letters to go out from Illinois. It's clear from the RFP, it's clear in the discussions. Parties worked toward a contract in July. At some point, you can tell from the emails that we've attached to the summary judgment, Microdynamics is getting a little bit frustrated because there's a lot of talk, but there isn't a contract signed. That's not unusual in this sort of situation, right? If I'm the buyer, I want to get as much free advice or as much pre-work as I can before I commit. If I'm the seller, I don't want to do any more work than I have to until I get that signature on the dotted line. They signed the contract at the end of July, and this is crucial. The first week of August, just 7 days or so after they signed the contract, Meredith Seville, she's the project manager for Microdynamics. She's the person who's going to be the liaison to get this relationship from A to B, toward a rollout of C or D in several months. She writes to Vito Horsfeld and she says, our concern has been, not is, has been, whether or not remote collaboration, which is this existing template software they have, is the correct solution for your requirements. That email makes it clear that the fix or the solution that Microdynamics was assuming back in March it could use, by a few days after the contract was already in question. Meredith Seville, Microdynamics' own project manager, raises that.
Counsel?
Yes.
I'm gonna back up to before the contract, and maybe even a few days before. Are you suggesting that Microsoft thought everything was a go and no problem? Because I thought I read something in the brief, and it seems like you are alluding to with coming out and saying that, I guess I should say Equity, knew everything was okay. That it got to a point where Microsoft said, we're not doing any more until you sign the contract. And then Equity signed the contract, correct?
Correct.
Well, I mean, at that point in time, everything wasn't lining up, was it?
No, Your Honor, and
But yet Equity still signed the contract.
yes, Your Honor, and as Dale Hartman explained in his deposition testimony, it's not that unusual. When you have a project like this, you have sort of several stages of development. At some point, you sign a contract, even knowing that there will be some development going forward. And, it would be typical to provide, in fact, that relates to our discussion of that term agreement, that term issue that the trial court found not just positive.
Well, it may not be that unusual in the business world, but then when you go to say, well, they could never satisfy our requirements, and you knew that before you signed the contract, or suspected, or, were concerned about, maybe you didn't actually know it, does that put a different flavor on, what is or isn't okay?
No, Your Honor, no, I don't think it does. The contract is clear. They have an obligation to perform print and mail and letter management solutions as fleshed out by the RFP and the parties' discussions. I suppose there's a continuum, right? If you're contracting with a party, you may contract with someone to build a house or to deliver goods or represent you hire me as an attorney to represent you in a lawsuit. And there's a continuum from 100% confidence to 0% confidence. Obviously, the parties came to an understanding that, we believe you when you say that you can deliver these 4 out of 4, and you've shown us some preliminary work and talked to us and talked up your ability. We believe you. We feel confident enough to sign. Now, to be clear, what Equity Trust was looking for was consistent with what the parties had always discussed. The RFP itself talks about one-off letters. It talks about Equity Trust's ability to print stuff in Ohio, not on a one-off basis, not in Illinois. It talks about the need to have a custom solution that integrates with this overall software overhaul that's going on at Equity Trust. So we get to August. Meredith Seville is, again, frank and upfront with Equity Trust, saying, hey, I think that the solution that we've been talking about might not work. Then Meredith actually gets another job, leaves the company. New folks, including this Jeremy Youngren, move into the liaison role with Equity Trust. In September, there is a series of emails, again, internally at Microdynamics, contemporaneous emails of their thoughts and beliefs, which is far and away the best evidence of what was going on, and perfectly appropriate as a basis on which to grant a Rule 56 motion. They say, Adam Strack, their head computer person, the head technical person at the company, says, and this is in an email from the first week of September to his colleagues, I know I am repeating myself, but I am concerned how we have represented our solution in phone calls with Equity Trust. In that email correspondence among the parties, there's not a discussion about how Equity Trust moved the ball, changed the requirements, added things, or anything like that.
What about her statement that Exhibit K shows 30-plus tasks that were required on the RFP, and then Exhibit T shows the additional stuff that was added in September, presumably toward the end of after the contract was signed? Is there, in your mind, what significant difference is there between those two exhibits?
There is the second exhibit, the later exhibit, is just further fleshing out. Obviously, if you enter into a contract that's complicated, the actual initial contract can't spell out every detail, every discrete thing. Just like a contract that you would have to buy a house doesn't specify specifically what brand of faucet goes in the master bathroom. The detail requirements contract, the document that was circulated in September and the one that Ms. Honor claims was a huge change to everything, simply fleshed out in additional verbiage the particulars of the deal.
That would be Equity's version of the difference.
Well, no, it was fleshing out with more particularity, somewhat more granular particularity, the specifics of the functionality. So instead of maybe, kingdom or phylum level discussions of functionality, you're getting down to class and order and genus and species eventually.
But again, that's Equity's take on the differences. Microsoft, I'm sorry, whoop, let's leave Microsoft. Microdynamics would not agree that those are the differences.
Well, no, I don't know that they disagreed. The fact that they received these lines of information and realized that they, were running around behind the scenes trying to fulfill them, at some point they came to the realization where they said, we just can't deliver what Equity Trust is expecting.
No, they're saying Equity changed the terms of the contract.
No, they're saying that now, Your Honor. That discussion doesn't show up anywhere, even in their internal emails or even in their emails to Equity Trust. And that's great evidence that they didn't believe that at the time.
When does it first show up?
It doesn't show up until after we cancel the contract. And then it takes a kind of a litigation perspective, and they realize that Equity Trust sort of called their bluff.
Move the
They're-
goalposts.
Well, yeah.
Now they're saying the goalposts got moved.
Well, and you can imagine that if you're having trouble satisfying your customers' requirements, and then you realize, holy smokes, I'm gonna have to go out and buy this NaperSoft, or I'm gonna have to hire software people. We're not a software company. I'm gonna have to go out and hire software people to deliver the goods. I'm gonna need to try to squeeze some extra money out of them. That's what they did. That's what this September 10th email is from Jeremy Gundry. And it can't be read as anything but a repudiation of the contract. They're saying, hey guys, let's work on this bulk print and mail, because that's 10% of the work and 90% of the revenue for Microsoft. And by the way, we're not gonna be able to deliver on your letter management right now. It's gonna require a recalibration of expectations. We need you to have, to provide extra resources and extra time for us to deliver what you want. His email doesn't say anything about how we've moved the goalpost, changed the requirements, or anything like that. And frankly, what happened was Equity Trust had had enough. When it got that email, as Vita Horsfeld testified, she was already realizing that Microdynamics couldn't do and didn't have the software that it had represented it could or would. And when the September 10th email comes and they ask for more money, that was the straw that broke the camel's back. Not only are you not performing, but you're saying, okay, we're gonna hold you up for extra money to get what we had already agreed to give you. Your Honor, if you have no further questions, I'd ask respectfully that this court should affirm the grant of summary judgment by the trial court.
Thank you very much. Attorney Hunter, you have about 3.5 minutes, ma'am.
Thank you, Your Honor. Now, Judge Callahan, I believe that you were asking questions about when Microdynamics, or where there's evidence showing that Microdynamics suddenly was realizing that these were new. And that actually comes in an email that was cited by both Equity and by Microdynamics from Mark Lowey. The email is on page 5 of Microdynamics' reply brief. And in that email, Mr. Lowey actually says it's to Mr. Harder and Mr. Schultegger, two Microdynamics employees, and he's saying, just keeping you in the loop on this, attached are a series of requirements documents, in parentheses, received today, provided by Equity Trust. That email was sent in September, that was sent after the contract was signed, and that's when he starts questioning what Equity Trust is asking. And he says, received today, showing that that came about. As far as Mr. Alton's contention about the request for extra money, as I mentioned before, that was actually contemplated in the contract, that if Equity Trust made any changes, this was a 5-year contract, so if Equity Trust decided it wanted to make changes, paragraph 1 of the contract says, Microdynamics isn't obligated to do it, but if they do opt to try to perform the required tasks, it is doing so at its own choice, and it may incur an additional expense. That's exactly what Microdynamics was trying to do. They were trying to salvage the relationship. They wanted to meet these requirements. And Mr. Alton listed a few things that were listed in the RFP, and in his mind had not been changed when they started fleshing them out into the post-contract requirements. He mentioned the ability to print a one-off letter. Microdynamics can do that. They said in deposition that they can do that. They stand by that today. The ability to print remotely. Again, Microdynamics can do that. They allow that capability for its clients, that they are able to print something from their own printer. But as this court can, I'm sure, appreciate, the fact that you're able to print something to your own printer in your office or at your home or someplace else is very different from the ability to say, all right, my kid printed this document at 2:35 and made these changes. Just the ability to print remotely is not the same as the auditing abilities that came about post-contract and those requirements. Mr. Allen also pointed out the timing of Microdynamics' response to the ad hoc RFP. He mentioned that it was sent just days later. That was done by Equity's own choice. Mr. Hartman sent that email with the ad hoc RFP. It was about a month or so after they had already sent it to other potential vendors and said, hey, can you get this back to us tomorrow? Microdynamics took a little bit extra time in order to prepare the response and get it over to them. But the rushed situation was actually done at Equity's request. It still gave Microdynamics time to get the team together, both sales and technology, and put together their proposed solution. As far as software goes, Microdynamics was proposing a software that it possessed called Remote Collaboration. It's a Hewlett-Packard software, and the literature explaining how that software works was attached in the literature that was included in Microdynamics' response to the RFP. And with that, if there are no further questions, thank you for your time, and Microdynamics requests that this court use de novo review to overturn the trial court's decision and grant judgment in Microdynamics' favor.
I
Thank you.
guess I do have a question, just based upon
Yes, Judge Callahan.
like your last sentence. The software that you referred to attached to the, we're talking about the original RFP, correct?
Correct, Your Honor.
Was there some cost involved with that that was supposed to be passed on to Equity?
No, Your Honor, that was the software that Microdynamics already had.
Thank you.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and the Supreme Court.
Thank you.
Thank you.
Thank you.